Hello everyone, thank you very much for joining us today. I'm going to be speaking about the Queensland franchising in 2026 and new rules and regulations that have come into place to shake up franchisors and franchisees and what you actually need to understand. So we're going to go through what's changed and what you essentially need to do now as either a franchisee or franchisor or looking to be one of those people in the future. So a little bit about myself and the team here at NB Law Group. So we are part of NB Law Group, which essentially has 4 pillars. Myself, Kaylee, I'm the director and take care of the NB Property Law team. I also take care of the NB Commercial section. We've also got NB Employment Law and NB Migration Law. So as part of my role, I essentially, help clients to, assist with them, whether it be commercial, property, or estate planning needs. I work closely with both individuals, families, and also the business owners to help them navigate their complex property transactions, their commercial contracts, and also their long-term asset protection strategies with confidence to make sure that they understand what is going on with their situation, that everything is protected. I've got extensive experience in both commercial property and also estate planning law, so I'm able to advise my clients on matters including their wills, testamentary trusts, asset structuring, and also succession planning to ensure that their wealth is actually protected both now and into the future. In terms of my commercial and property law background, it also enables me to help clients be able to deliver integrated legal advice to support their individual and also their business development growth and their risk management for those things. I'm passionate about both commercial property and estate planning law, and I'm always striving to provide the holistic, practical legal advice that aligns with my clients' broader financial and business objectives. Essentially, above everything else, though, I like to prioritize actually delivering advice to my clients in a clear commercial way so that they're actually able to understand what's going on and ensures that all our commercial transactions have the right outcome and generally support my client's success. So in terms of today's session, so we're going to be talking about the franchising in Australia and entering into that new regulatory era. So Queensland businesses, we need to be staying ahead. The remade franchising code of conduct come into effect as of the 1st of April 2025, and the key provisions from that mandatory code come into effect from the 1st November 2025. So we're going to be talking about those introductions of those significant reforms and how they're impacting essentially on the disclosure obligations, the franchise agreements, the dispute resolution processes, and also the compliance risks for both franchisors and franchisees. So thank you very much for joining us for this exclusive webinar today, and we'll hopefully break down for you what's actually changed and what you need to do now to manage legal risks and ensure compliance for yourself in 2026 and beyond. So essentially, franchising a business can be a profitable way for people to expand a successful existing business. So there's many well-known brands that have done this, such as, McDonald's, Domino's Pizza. They've used that franchising to finance and accelerate their growth from a local business into essentially a leading global brand, while other Australian homegrown franchises have also used the model to become a household name throughout Australia. So Australia currently has over 1,200 franchise systems with over 94,000 individual outlets, and it generates an estimated $174 billion in annual revenue. So the Franchising Code of Conduct is a mandatory industry code under Australian law that regulates how franchisors and franchisees must behave in their business relationship. So as mentioned before, this come into effect on the 1st of April 2025 with the major mandatory components coming into play from November 2025. The conduct of franchisees and franchisors on or after that date in relation to such agreements, it now needs to comply with these new regulations. So the key features from this code are the disclosure requirements, the good faith obligations, and the agreement rules, and also the specific purpose fund rules, and lastly, the cooling off period. So we'll go through some of the key changes, which includes the termination rights, the compensation requirements for early termination rights, the strengthened franchisee protections and the fair dealing obligations, the restraint of trade clauses, the specific purpose funds, and the expanded civil penalties. We'll talk about the name and shame powers and also the disclosure registrar. So in terms of the termination rights, so in the event of a serious breach of the franchise agreement, a franchisor may terminate the agreement with 7 days notice. So a serious breach by a franchisee includes if they no longer are holding the required license to operate the business, if they become bankrupt or insolvent, if they are a company, the company becomes deregistered, if they're found by a court to have committed a serious contravention of a Fair Work civil remedy provision, or if they're found by a court to have contravened, or if they're actually convicted of an offence under certain Migration Act provisions. So this section 57 prohibits the franchisee from actually disputing the termination provided the agreement is terminated under particular grounds. So although the franchisee still has the option to take the matter to court, the reasoning behind this is because due to the serious nature of the breaches, a franchisor must be allowed to act quickly to protect their brand. In terms of the last point that we mentioned there, in terms of the Migration Act provisions, this relates to coercion and also undue influences on the lawful non-citizen workers. So there's a few termination rights now and that have come into play if there's a serious breach. And obviously noting that, yeah, they've got that 7 days notice to give notice to actually terminate. So the termination rights with a franchisor, they can terminate the agreement on the following grounds, but the franchisee can actually contest the termination. So if they don't think it's valid and lawful or doesn't actually comply with these grounds, then that can actually be contested. So the grounds the franchisee has for terminating is for voluntary abandonment of the franchise business. If it's been operated, the business in a way that actually endangers the public health or safety. So, if it was maybe breaching workplace health and safety rules, if, it was hospitality business and they weren't complying with, the food safety standards and things like that. If it's being operated, the business fraudulently. So, that could be a vast array of things. If it was selling goods that are considered illegal, drugs and things like that, or selling, alcohol to minors and those sorts of things would all be termination rights. So moving on now to the dispute resolution process and what this actually looks like. So if a franchisee disputes the termination, they must provide notice, and this will start the dispute resolution process. So the notice must outline what the actual nature of the dispute is, what the outcome that they are actually seeking from raising this dispute, and the actions required to actually resolve the dispute. So the parties need to attempt actually to solve the dispute between themselves within 21 days of this notice. And if this fails, then they can, of course, move to the next step in the process. So this process will essentially, pause the termination, essentially. All right, so alternative dispute resolution, it does follow pathways and it is available to parties if no agreement can be met internally. There are a few different forms of alternative dispute resolution, and they include mediation, conciliation, and arbitration. So with a mediation, you essentially have a third party, a mediator, to sit between the parties to try and mediate an outcome. With conciliation, it's a bit more, I suppose, a bit more forceful. Again, a third party, a conciliator, but they'll be working with the parties to try and come to an agreed outcome. And then arbitration is the last option. Now, the code requires that both parties act in good faith and engage in these meaningful participation of the ADR resolution process. So it's not okay for one party just to turn up and essentially not say anything, or basically just, you know, override the other party, speaking over the top, not trying to come to an outcome. Like, the purpose of the ADR is to try and, you know, come to an agreed outcome and actually take place in these bargaining, you know, agreements in good faith. So this includes, you know, actually showing up for meetings on time, providing the relevant information, and not delaying the process. So, you know, there's no point in you know, turning up to any of the forms of ADR and essentially just saying, you know, we're not going to agree to anything today. It's a waste of time. We're simply here to tick the box, and that's it. If the dispute resolution clause in the franchise agreement does not meet the minimum standards, then the code's procedure will actually apply. So compensation requirements for early termination. So if, you know, we've tried ADR, that didn't work, and, you know, whatever reason we are going through to terminate the franchise agreement, the franchisor can terminate a franchise agreement early due to any of the following. So it can do so if it's withdrawn from the Australian market. So this could be an overseas global brand that's looking to branch out into Australia, into a new, whatever reason, you know, maybe they've opened a couple of stores or something like that, and it's not work, and they're deciding to withdraw from the Australian market altogether. If the rationalizes or restructure its network in Australia, you know, similar situation. So, you know, it's decided to do a whole restructure, and, you know, maybe it's a global brand that's part of a bigger group, and it's got, you know, maybe 3 different brands under it, and it's deciding to close one of those brands and only continue operating the 2. The last option is if there's a change in its distribution models in Australia in a way that impacts the franchisee. So, you know, that could be, for example, I guess, you know, the common one at the moment, probably, you know, petrol, getting oil from overseas, and, you know, 7-Eleven saying, oh no, it's too expensive. It's, you know, we're no longer gonna, not gonna happen at the moment, but no longer gonna import, you know, oil or whatever the good or service is into Australia, and we're therefore just, you know, closing down that altogether. So the requirements used only, only apply, you know, in this way if one of these were to pop up, essentially. So what the compensation must actually cover off on then. So the franchise agreement must now include how compensation will be calculated in the event of an early termination, which we went through in the previous slide. So we must be considering, you know, what was the actual loss of profit. So, you know, we've come into this business, you know, like I said, it could have been an overseas brand, and, you know, they've decided to shut down, you know, the stores that they've got here in Australia, but there has been a franchisee that's essentially then, you know, lost out on profits. They've basically need to be compensated for the cost of the fit outs that they've undertaken, which could have been, you know, quite extensive. They might have, you know, undertaken a, you know, $1 million renovation to the shop front, or, you know, the equipment that they've purchased, or any capital items that the franchisor you know, required. If there was loss of opportunity, so, you know, they had, you know, seen the opportunity, knew it was going to work, done their forecasting figures and things like that, you know, that loss on opportunity cost will come into play. The cost of actually winding up the business. So, you know, if they do have to, you know, wind up the business because, you know, they've gone in there, the franchisee has gone into insolvency or the likes, then they're, you know, got cost involved in that, in, you know, going out and sourcing the liquidator, and, you know, if there was no money left in the bank of that company, you know, forking out the costs needed to do that. Any stock and inventory compensation as well. So, you know, this franchisee, you know, might have had a lot of stock and things like that that they'd had as part of, you know, opening the shop, but all of a sudden, you know, that's no longer needed. Maybe they did go into liquidation, and then they're obviously left with this money as well, which is coming at a detriment to them. So the reasonable opportunity then to make the return on investment. So all franchisors must now ensure that all franchisees, if given reasonable opportunity to make a return on investment. So, you know, there's potential issues with this requirement in what is considered a reasonable return, and does the franchisor need to consider the landlord's required fit-out costs and the refurbishment costs along with their fit-out cost requirements. So, you know, as I mentioned before, fit-outs are not necessarily cheap. You know, construction costs are high at the moment. You know, trades are hard to source. You know, they could be looking at something like $1 million to fit out the premises to comply with, if they're in a big shopping centre like a Westfields or something like that, but then also needing to comply with what the franchisor requires too. It can come quite an extensive cost for them. So what needs to actually be considered is the agreement term is long enough. So obviously there's no point, having this franchise if it's only for a short term, period, and all of a sudden they've forked all this money out. There's really not going to be any return on investment in that regard. Are the projected revenue, the margins, the rents, the input costs, and any other capital requirements actually realistic? So has the forecasting, for the projected revenue been done, adequately? Is it based on, other franchisees within the group? Or if it is, a global company, has it been based on what those projections are overseas? Looking at the Australian market as to what they consider the return on investment here. The margins. So, if we're as the franchisee being made to purchase, the products from the franchisor or their preferred suppliers, is the margin that they're going to receive then on those goods sold, enough to make it, a good return on investment for them. Looking at the rents again, knowing what we're projected to make, knowing that the margin that we're going to make as the franchisee, is the rent then going to be able to be paid? And what are the input costs and the capital requirements? So, what have they got to put into that? We need to look at, the refurbishment equipment upgrade costs for them to make it commercially worthwhile. So, although there could be fit out costs, as I spoke about at the initial lease stage and when we've taken over the premises, but there could also be refurbishment and redecoration costs. So again, the example I gave before was a Westfield lease. A lot of those big shopping centre leases do have refurbishment clauses within their leases that every 5 years, for example, they must do a whole refurbishment of the shop front and make it something new and more appealing to keep up with the modern trends, and also redecoration and make good. If once the lease ends as well, they've essentially got to put a lot of money into making good that lease premises to bring it back to essentially the bare shell in a lot of cases. The other thing to look at is, are the initial investment costs actually reflecting the business's potential? So there's a lot of upfront investment costs, and they need to be feasible to ensure there's return on investment for what the actual forecasted business potential is. Restraint of trade clauses is the other one that we spoke about at the start that's changed. So for any agreements now entered into or extended or even transferred or assigned or renewed on or after the 1st of April 2025, their franchisor cannot enforce a restraint of trade clause if these conditions apply. So essentially, if there was an option to extend or renew, and the franchisee exercised their right to extend or renew, and the franchisee met the requirements for the renewal, but the franchisor did not grant the extension or renewal. So if the franchisor enters into an agreement that breaches this new section 42 of the code or attempts to enforce such a clause, then they can face maximum penalties of 600 penalty units, which currently this is equivalent to $330 per penalty unit. So essentially up to $198,000 in fines is the maximum penalty if they were found to be in breach of this. Obviously that's the maximum, meaning the worst case scenario, but if a restraint of trade clause this section was breached, it would essentially look into similar case law to determine what severity this had and what impact it had to work out whether the maximum would be applied. Now, the specific purpose funds. So a specific purpose funds are funds that are controlled and administered by the franchisor for any of the following purposes. So this can be for marketing, training, IT, any conferences that may be held, any environmental or sustainability funds, and essentially any other franchisor controlled fund created for an actual defined purpose. So a franchisor must now disclose what the actual purpose of that fund is. So it's no longer okay just to say, you know, we've got this fund and you've got to pay this amount, then there needs to be a definite purpose for the fund, the expected benefits and associated risks of the fund. So it's not enough just to say, yeah, we've got this fund, this is what the purpose is. It does actually need to directly correlate to actually have a benefit, and also outline what the associated risk of having this fund would be. It also needs to go, now franchisors must disclose what the nature, the amount, and the timing of the contributions are. So, you know, when must each of the franchisees be paying the amount, and on what date is it due, and, you know, in what nature. So how do they go about paying it? You know, direct deposit or something like that. A franchisor is also required to provide an annual financial statement of the fund as well. So, you know, they'll often give, you know, the estimates of what these figures will be. And at the end of each financial year, this needs to be evidenced by the franchisors. They need to send out to all the franchisees, you know, to prove essentially, you know, these funds are being used adequately and that they were the correct amounts that were, you know, on charged to the franchisees. The new disclosure requirements now also mean that a franchisor must include the following information in the disclosure statement. So, any significant capital expenditure that the franchisee may be required to pay for. So this could be, you know, this could be many different things. It could be, you know, capital expenditure could be a range, and it will depend on what each franchise business is as to what that is. But essentially, they need to be disclosing that upfront now to the franchisees so that they know that it's required to be paid, and they can essentially account for that in terms of their cash flow and budgeting. The statement of the franchisor's solvency must also be disclosed now. So, you know, obviously this is to avoid a franchisee entering into a franchise business with the franchisor who's essentially on the brink of going into insolvency. And, you know, then the franchisee is essentially got no outcome for the money they've invested, because, you know, the business is going to be shut down. So how the franchise agreement supports a franchisee must be disclosed. So, you know, that will just go into a lot of detail about, you know, what the franchise is going to do. It might talk about training and marketing and things like that as to how it's going to support this franchisee to build this business. It's going to speak about the cost of actually setting up and running the franchise. So, you know, those different funds that I spoke about before, it will outline, you know, what the cost of each of those funds are, what marketing fees are, what the ongoing, you know, the rental costs, the margins for the supplied goods that they've got to purchase from particular people. It will go into all those details. It will also have details of any legal action against the franchisor that relates to the franchising. Obviously, that is important because while the franchisor could be solvent at the time of entering the agreement, if there is quite a large litigious matter that's going in the back end, you know, that could have a really big outcome on, you know, the solvency of that franchisor if the litigation doesn't go in their favour, which is why it now needs to be disclosed. Now, details about any specific purpose fund as well, which is what we talked about before, which, you know, needs to now be disclosed as to what, you know, what it is, what is the nature of it, and what are the fees associated with that. So this update basically means that these must be provided unless the franchisor did not enter more than one franchise agreement in the last financial year, and they don't intend to enter into a franchise agreement in the current financial year either. If they do, then are essentially exempt from this section. And they also must not have received a written request for the disclosure document from an actual franchisee. So at any point, if the franchisee does request one, even though they may be exempt, they still are under a requirement to provide that information. So the franchisor must include the following information. So any material facts, including details of any litigation, any change in ownership, and any major business risks. So we spoke a little bit before about the litigation in terms of change of ownership. So that could be, you know, multiple different things in terms of, you know, maybe they're going through a whole restructure. They might be looking to, you know, set up an acquisition or a sale, a merger of the business as well. And if there are any major risks as well, it needs to be disclosed. And you know, the list is kind of endless as to what the examples of that could be. But as a franchisor, it's their obligation to disclose. And if they're unsure, obviously they should be seeking the advice from, the legal professionals, like ourselves to disclose them. They need to also disclose the contact details for current and past franchisees. Obviously, the reason for that, for incoming franchisees, they want to be doing their reference checks and things like that, and they may be reaching out to those particular current and past franchisees to see, how they found the business, and to determine whether they're going to continue in it. The details of each franchisee that has ended their franchise agreement in the last 3 years. So it doesn't need to be any franchisee, beyond that period, essentially just in the last 3 years, because obviously the list would be extensive and that's, going to be of no relevance. And needs to also be disclosing any rules relating to goods and services that the franchisee must buy or sell, including all the supply arrangements. So if the franchisee is going to be made to purchase particular goods from suppliers, that all needs to be disclosed, along with any financial benefit that the franchisor is going to receive from those supply agreements. So if the franchisee is being made by the franchisor to purchase goods from particular suppliers, and that supplier is essentially giving a kickback to the franchisor, then the franchisee now needs to be made aware of that through these new disclosure requirements. So the franchisee can opt out of including their contact details in the disclosure. So a lot of the times, they may not want to be contacted, particularly if they are one of the past franchisees, in that 3-year period. However, a franchisor cannot encourage a franchisee to actually opt out of including their contact details. So the financial benefits as well include like any rebates and other benefits that the franchisor or the master franchisor or even an associated or an associate of the franchise of master franchise actually gets from those suppliers in terms of, whether there is those kickbacks, is how that will operate. So disclosure, it's a lot. There's still, many things, we're probably only touching the surface on here today, but there's so many different examples and so many things, which is why there's such a large document. So important to obviously make sure that they're reviewed in detail and they're drafted correctly as well, because we don't want to have, an inefficient or an ineffective disclosure document that essentially, leads to legal recourse from the franchisee. So the other disclosure requirements are for the franchisor that they must include any potential changes to the planned distribution models. If there has been any, proposed changes, they need to be included and disclosed. If there's been any proposals to the restructure of the network, we need to now be disclosing them. We need to, as a franchisor, disclose how the franchisor is actually going to provide the franchisee with a reasonable opportunity for the return on investment. Now that could be done through, a number of different things, but obviously probably the most common one will be through, forecasting and modeling and, outlining, what the costs are and what they see as the return on investment. And that may be based on your previous case studies, or, if they are an overseas franchisor entering the Australian market, it might be looking at some of those opportunities that they've had overseas and how they see that will correlate here in Australia. Also needs to be disclosing the cooling off period and the opt-out options. So, what is, essentially the cooling off period, and how does the franchisee, essentially opt out of the option periods. Must also detail if the agreement permits arbitration. So we spoke about, towards the start, about the alternative dispute resolution, and with that there's generally 3 options: mediation, conciliation, arbitration. Now, if arbitration is an option, it must specifically disclose that in these new disclosure requirements. If there's been any required or recurring contributions, so any fees that are required to be paid or that are ongoing costs, they must also be disclosed. And what the actual financial assumption used to support the return on investment actually must now also be disclosed. So we must also be disclosing what the purpose of the fund is, which we spoke about before in terms of, what is its nature, what is the amount, what are we using it for, who actually controls and or administers the fund. So, is it whoever? Is it the accountant for the franchisor, or is it, the treasurer? for the committee that they've, got a board together for, whoever that is must be listed and nominated. Who else will be contributing to the fund? So, is it just the franchisees, or, does the franchisor put their own amount of money into this fund for a particular reason? It needs to be outlined and disclosed. The kind of expenses the fund will or can be used for. So, if it is a marketing fund, what can that money be used for? Can it be used for TV advertising, radio, whatever? It needs to be disclosed. How much the franchisee is actually going to contribute, and if the contributions are equal for each contributor. So we've got, obviously, for example, a franchise network where we've got multiple franchisees in different locations across Australia. Some of them are obviously going to be a lot more insignificant than some of the, the bigger franchises that are in a prominent location, or, major city or something like that. So often they may not be paying equal contributions to, someone in a rural town, but it still needs to be disclosed. Each franchisee have the right, and, will have the knowledge by looking at the disclosure statement to know that. If the franchisor will spend part of the fund to benefit the franchisee business. So essentially, if we are putting money into this fund, what amount of that we're putting in is actually going to benefit that actual particular franchisee's business. Like, it's fine to put in money, like I said, for marketing, but if the marketing's only been done and geared towards, maybe Sydney instead of, our Brisbane store, then, that's going to be an issue. So we need to make sure that's disclosed. We also need to request also information relating to the preparation of the annual financial statement, the auditing and the financial statement, and if the franchisor, the master franchisor, or an associate supplier of any goods or services that the fund actually pays for. So we've now got some prohibited clauses that have come into play as part of the code. So as we spoke about before, the restraint of trade one is one. Essentially, it cannot, it's not okay for it to be undisclosed significant capital expenditure anymore. Another prohibited clause is the missing or non-compliant early termination compensation provisions. We can no longer have unlawful cooling off and opt-out provisions, and the terms that contradict essentially the disclosure obligations. So the franchisor must disclose significant capital expenditure in the disclosure statement, and they must discuss it with the prospective franchisee. So the agreement cannot contain clauses that essentially prevents the disclosure of materially relevant facts, or essentially overrides the franchisor's obligation to provide the updated information. So what else do we need to be aware of then? So we've also got the Australian Small Business and Family Enterprise Ombudsman. They now have the power to name and shame franchisors who do not participate in a meaningful way in the ADR process. So I spoke about at the start, this ADR process has been put into place for a reason, and that reason is, that it is actually used as a first step to try and resolve disputes, rather than essentially clogging up the courts to try and, make claims through the courts. Not everyone can afford litigation. Yes, the franchisor may be able to, but the franchisee may not, and they're at a disadvantage because of that. So ADR is an important step, and it must be complied with. Otherwise, if it's not, they can name and shame for not doing this, and the penalties are essentially increasing. So a breach of a substantive obligation carries a civil penalty of up to 600 penalty units, which is the same as what we spoke about before, which is 198,000. So it is a significant amount of money if that maximum penalty is enforced. The ACCC can also issue fines for failure to maintain the franchise disclosure register. So a couple of different options there of what can happen if that ADR process is not participated in a meaningful way. So the obligations are the restraint of trade clauses, they specific purpose funds obligations, providing reasonable opportunity to make the return on investment, and early termination obligations, updating franchise disclosures, cooling off periods, and the ADR obligations, which we've gone through just now as the example. So a lot of changes that we've seen come into play, this has probably been the biggest changes in this space in, the last decade. Australia is, one of the most franchised nations per head of population in the world. So this essentially means that, the awareness to franchising is at an all-time high, essentially. So many individuals and organisations with the existing businesses, therefore see franchising as an easy route for expanding their business and getting rich quick. And, you'll be amazed by how many people ask, for help with a franchise idea that they've got. So that's why these changes have come into play, to try and regulate it a bit more, provide some compliance and new legislation to make sure that, it isn't just a get rich scheme, and that franchisors are, under heavy obligations to disclose to the franchisees, what is going to be their return on investment? How is that going to happen? What are all these contributions and funds that they're paying to? So the new franchise code of conduct, as I said, come into place in April 2025, so essentially last year. Most of the other mandatory parts of that code come into effect in November 2025. So it is quite new. Everyone is still trying to, work out, what is and isn't needed to be disclosed. But essentially, this new code of conduct is designed to essentially address the power imbalance that previously took place between franchisors and franchisees, to ensure that they're essentially on an even, a more even playing field now. So, franchising is, it's not a testing ground for a brand new business idea. You need to make sure that you're running a successful business for a sustained period of time before you even actually consider going down the route of franchising. And, this is why, these changes have come about. It's been put into place to essentially raise the fairness, the transparency, and the actual conduct standards across the sector, to make it, a more fair, area for both parties. It's also helped to improve both the clarity and disclosure, so that the franchisee can actually make a better informed decision, rather than just, rushing into something because they've heard from a friend, or they've been given the marketing material, by the franchisor that kind of sounded okay, and, they want a quick business that's easy to run, and they've got, the back end support that they think they're going to get from the franchisor. It's also essentially, strengthen that access to the fair and effective dispute resolution pathways. Like I said, we now need to make sure that we're disclosing how the ADR happens. If arbitration is option, it must be disclosed. And if a franchisor doesn't adequately participate in that ADR process, then, as I said, there are severe penalties, up to 600 penalty units. ACCC can issue fines as well, and they can be named and shamed as well by the ombudsman. Another final point is probably, it's helped to enhance the regulatory oversight and accountability needed by franchisors to franchisees, which, I think, like I said, we haven't seen these, changes as significant as this in these 10 years. And so it was, definitely overdue. So essentially, yeah, you want to have a successful business, you want to look at franchising. You still need to determine, is your business suitable for it? If so, what you need to look at. And, some of these things that we spoke about today are the things to start thinking about and collating and working out, how it's going to all be disclosed to the essential incoming, franchisees. Australia has some of the world's, most stringent franchising legislation. We are aware of that. It's primarily intended to actually protect the franchisees who may have little or no business experience, which means, there's sometimes no margin for error with our franchisors. So it is important that they're getting that proper legal advice at the forefront, which we at NB Law Group can help to work closely in conjunction with your business advisors, your accountant, assisting you in preparing all the legal documentation required to actually roll out your new franchise. Whether that be the master franchise agreement, the actual individual franchise agreements, if you need to go through the whole trademark registration process, any associated IP license agreements as well, documenting any business systems and training materials, we can help with all of that as well. So practical steps, I guess, now to actually protect your franchise business in 2026. So you need to make sure that the franchise agreement does not contain any of the prohibited clauses that we've gone through today. You need to be checking that the fee structures and, providing realistic financial assumptions to make sure that the agreement supports the return on investment opportunity. We went through that in detail before, what are the forecasting? How has it worked out? How is that going to be a benefit to the franchisee in the long run? Need to ensure that the disclosure register entries are up to date and they're always kept current, and the franchisees are made aware of this. We need to be ensuring that all specific purpose funds are accurately disclosed and the funds are used for the disclosed purposes. So like I said, before, what are the funds that we're going to have in place? And when are they payable? How are they payable? What is the purpose of them? Is that purpose specifically related to that franchisee business? We need to be updating your disclosure documents annually as well. So it's fine for you to check this now, but you can't set and forget. If things change, they need to be updated, because every year you need to be providing those disclosure statements to the franchisees and making sure they're accurate. And whenever a material relevant fact occurs, we need to be letting the franchisee know of that. Now, we also need to make sure that we've got a plan in place to deal with disputes. I've spoken about a couple of times now that the alternative dispute resolution process, obviously probably thinking about setting aside a budget as well. Like, the ideal scenario would be that every dispute settled at ADR, but unfortunately that's not the situation, which is why litigation now needs to be disclosed to franchisees, because litigation is a costly expense. So, if we're thinking that we're, going to set up business and we're never going to have disputes from anyone, that's an ideal world, but it's not reality. Lawyers, unfortunately, we exist because disputes do arise. That's why we're drafting these documents in a compliant way to make sure that they don't arise. But even if we've done everything we can to try and protect ourselves, there's still going to be disputes. So we need to make sure that we've got the plan in place to deal with that. We need to be ensuring that the relevant employees are aware of what the dispute resolution obligations are as well, because we've got many key employees in a franchisor business. We might have boards, we might have, several directors, whatever it is. They need to understand what their dispute resolution obligations are, because, they essentially could be form part of it. It probably is important to mention as well, with franchisors, they are, in terms of employment law as well, under Fair Work Act, there is essentially accessorily liable as well. So as a franchisor and even their franchisees, if they don't follow workplace laws, this is essentially a franchisor liability, and they could be considered, being in breach of this Fair Work Act, and breaches will apply, and these will extend to the third parties, being the franchisor. So a personal company can be held essentially responsible as an accessory if they were involved in a contravention. So franchisors and even the holding companies can be held responsible for the franchisees and their subsidiary entities that they may have set up conduct, even if they didn't even know about the actual contravention. So, ignorance is not an excuse, and we need to be aware as a franchisor of this accessorial liability and when it actually occurs, because that's another thing that we need to be essentially mindful of and planning for. We need to be keeping records in an organised fashion. We've got a lot of disclosure obligations. We could have potential, court claims and things like that. We need to be able to access those records, in a succinct manner and know where they are. And, our key personnel, our key staff need to know that too. We also need to be keeping in mind the relevant timeframes. So, I've spoke about a few of them today, the 7 days in terms of termination. The other one listed here, at least 14 days before any agreement is signed or non-refundable money is paid. The pre-contract disclosure must actually be provided. So, we've got these strict deadlines now. We need to be mindful of them and we need to be adhering to them. 14 days after that agreement is signed, the franchisee then has their 14 days for the cooling off period. So the other time frame is the 21 days. So after receipt of any notice of dispute, the parties must attempt to resolve the dispute before the matter can proceed to the alternative dispute resolution, which, as we've gone through a couple of times, we need to be actively participating in that to avoid any penalties. Now, I know that's a lot of content, a lot to get your head around, big changes. It's not, I guess, a light topic, but happy to take any questions if anyone wants to pop them in the chat bar. Otherwise, feel free to take yourself off mute and I'll be happy to answer those for you. I'll just give a minute for any of them that come through. All right. We don't have any questions popped up in the chat bar, but I've got a couple more slides, so feel free. Oh, wait, there is one that's just popped up. Someone's typing, so I'll let them continue typing. And we'll do that in a second. Yeah, so one question there, just checking if we can get a copy of the recording afterwards. Yeah, so we'll definitely be sending a copy of today's session and also the slides as well. So do keep an eye on your emails. If you don't receive it, reach out to us. Potentially, maybe you shouldn't have put a wrong email because you're in this session, so you should have got the invite for it. So everyone should get it, but potentially it's gone to your junk or something like that. So feel free to reach out to us. Our team will also try and reach out to you as well to try and lock in a time for us to have a one-on-one chat and go through it in a bit more detail. Now, another question, do we also act for franchisees? So yeah, essentially the law is the same whether you're a franchisee or a franchisor. So we do act for both sides of the party. Now I've got this slide here, completely opposite topic to this. This is all about the new anti-money laundering changes and the compliance that's coming in for real-world transactions. This probably more affects your accountants, anyone essentially with a trust account. They don't even necessarily have to have a trust account. Buyers agents, real estate agents, accountants, us as law firms, we're all impacted by these changes that come into place in July of this year. We're doing an in-person breakfast for this one on Thursday morning, the 19th of March. If you want to scan that QR code there, you'll be able to register for this complimentary breakfast and learn a little bit more about the anti-money laundering new changes coming in place in July. I've also put up details if you are interested in looking to franchise and essentially start, your business journey as whether it be as a franchisor or franchisee and want to get a little bit more information. They are actually holding a convention at the Brisbane Convention Exhibition Centre this weekend, so the 21st to 22nd of March. If you want to scan that QR code, you'll also be able to find out more information there. There'll obviously be a lot of different exhibitors there, and you'll be able to ask information from real people and hopefully answer some of your questions. Otherwise, thank you very much. I know there may be questions that you haven't had a chance to ask. By all means, feel free to send them through to the email address listed here. Otherwise, feel free to give us a call and more than happy to have a one-on-one discussion with you. Thank you. A couple of thank yous there in the comments. I really appreciate your feedback, and yeah, we'll hopefully chat to you soon if you've got further questions, whether it be you as a franchisee or a franchisor, helping you navigate the legal minefield that it all brings. So thank you, everyone, and have a good afternoon. We'll chat to you soon. Thank you.